Hello?
Hello.
Yes, sir.
Hello.
Can you hear me?
I hear everybody.
Okay. I'm trying to find out who's who here. You are,
I'm Mark Roberts, Your Honor, and I'm appearing on behalf of Portfolio Recovery.
okay, let me find that. Versus who?
I think Jeffrey Chavez is the defendant.
Okay. Is there,
Yes, sir. I'm Diane Bistido,
uh-huh,
and I'm appearance counsel for Heston Law Firm, appearing on behalf of the defendant, Mr. Chavez.
okay. And have you had an opportunity to talk to Mr. Roberts?
I have not, my instructions are to try it, Your Honor. So I don't have any settlement authority anyway.
Your instructions are what? I didn't hear them.
To try the case.
Okay. Would y'all like to have an opportunity to talk first?
Your Honor, my client had asked if we could have a hearing not hearing, listen to me, a 30-day, short 30-day continuance, Judge.
And counsel, do you have a problem with that?
No, sir, not at all. I know that they don't ask for a continuance willy-nilly. They must want it for a reason. So I'm not going to object, Your Honor.
Okay. And will y'all be in, can y'all be in touch with each other?
Yes,
Sure.
my preference, Your Honor, is to settle these matters if we can. I don't know if it's the defendant balking at settlement or not. As I'm appearance counsel, I didn't get deep down into the case. So
Right. Well,
Yeah.
what I'll do is reset this case to no definite time.
Yes, sir.
And then when one or both of y'all agree on something or are ready for a trial or whatever, let me know and we'll go from there.
Thank you, Judge. I appreciate it.
Your Honor, that's more than fair. I certainly appreciate it.
And Your Honor, I do appreciate the Zoom hearings, Judge.
Oh, you're welcome.
Oh, I'd rather be there, counsel.
Your Honor,
I'd rather
may I
go
be
visit
excused,
the
Judge?
judge.
Hello?
That's all right.
Yes, it is, Judge. Yes, it is, Your Honor.
Uh-oh.
Mhm.
Well, I don't have anything further to add, Your Honor. May I go or?
You are dismissed and thank you for being here.
Yes, I hope I can see you soon too, in person.
That would be great.
Oh, it would. You have a good day, Your Honor.
And
Thank you.
where are you from?
I'm here from Houston,
I
but
see.
my family's all from East Texas, so
I see.
I'm not really a Houstonian, you know, not all the way.
I get it. I get it.
Thank you.
You're dismissed.
Thank you.
You're welcome. Okay. So that one's done.
This one they have not filed an answer.
No answer. Okay. And is this the file? Oh. You want to do this one next? With no answer. Oh,
Yeah, that's 0035.
Klein Appliances versus Kanema.
Yes.
Is that one you want to do?
Yes.
Okay. Do we know who's appearing on that?
I'm not sure.
Okay. Mr. Stevens, can you hear me?
Yes, sir.
What case are you on?
I have the Con Appliances, Brenda Neville.
Okay. Are you ready?
I am, sir.
Okay. I believe there's been no answer filed and she's not in this meeting or anything. Is that correct?
That's my understanding, sir.
Okay. If you would give me the short version, please, sir.
Certainly. This matter concerns a retail installment credit contract entered into between Con Appliances plaintiff and Brenda Neville defendant. This contract went in the account underlying set of contract for credit extension for the purchase and acquisition of various household goods and items from Con Appliances by the defendant. Went into default. It was thereafter closed, charged off April 30th, 2018. The breach of the contract and underlying defaults on said account resulted from failure to comply with terms of payment. The amount outstanding due and owing as of said date certain on the account being $3,376.25. Cons has now brought this claim against defendant. The defendant was personally served. Thereafter, the return of service has been on file with the clerk sufficient number of days. Defendant has failed to answer, otherwise appeared as required by law within the time period prescribed by law. We therefore filed our motion for default judgment in this case, providing the court with a certificate of last known address and non-military declaration as to the defendant, as well as an affidavit as to our business records and damages in this case. Such business records inclusive of the contract itself, executed by the defendant with Cons, the promissory note underlying, and the ledger containing the calculation and itemization of payments, credits, offsets, debits that are made towards or occurring on said account. The final tabulation for the liquidated damages sought in this case can be identified readily therein, as calculated therein, based on for these reasons and based on said documentation. We ask respectfully that the court render default judgment in this case as requested, and we have provided a proposed default judgment for the court.
Okay, and the court will,
I'm giving you the wrong one. So this one is the one where she did email saying that she has came to an agreement with.
on this one?
Yes.
Oh, okay, hold on, counsel.
Okay.
Sorry, she emailed on April 12th.
On April 12th, we have an email from the defendant stating she made an agreement with the plaintiff.
That's I see that, but I don't see that she ever returned the executed instruments. Now, my only concern here is we have an 8-day window. Now, that's a little bit long in the tooth for purposes of mail transmission. I don't know that this happens occasionally where the defendant will say, we've reached a settlement, we've agreed to their numbers, but they never actually return any of the documents. And so we're told to proceed. But if Your Honor is satisfied with our presentation and wants to continue this out, a week or two to see if anything transpires to where the agreement is actually reached via execution, we can do that. Or we can simply move forward. But at that, we have not received the executed agreement, settlement agreement, and underlying agreed judgment.
Okay, the court does want to continue this.
Okay.
And I would say I'm not going to continue it for a date certain. I would say within 2 weeks to a month, just let us know the status and then we'll go from there.
Okay, I'm going to make a note to contact y'all. Let's see, today is the 20th. Let me look at my calendar real quick. 27, 28. So let's say by the let's call it the first, second week in May, we'll make contact with the court, advising the court as to whether we did receive. Well, the court will know because we will have filed the documents, but we'll let you know one way or another if we get the instruments back, and if not, we can either go through this process all over again, or the court can proceed based on the presentation that was rendered today. I'll leave it up to the court to make that determination. I don't know how you want to proceed there.
We'll just play it by ear and see what
Okay.
happens and hopefully it may be an agreement.
Much prefer the settlement route. I always consider settlement a win, and a judgment is kind of a nullity. But let's just see what happens. The last thing I want to do is get a judgment, they get notice, and it scares the defendant off, and we never the settlement never happens. That's the last thing I want. So let's see how this, as you stated, let's see how this plays out. We'll see if we actually get those documents back from the defendant. I will send a notice out that we need to get that information back, and so that we can get it expedited over to the court so that the court can have resolution. Okay.
Is that the only case you have?
That is the only one. I'm done for the day. May I be excused, sir.
You sure might. And thank
Y'all
you.
have a good day.
You too.
Bye-bye.
Bye.
So this is the one.
Okay.
I don't know.
Oh, okay.
Unless it was happening.
Okay. Mr. Sweeney,
Yes, Sean.
how are you?
Pretty good. How you doing?
Pretty good. Can't complain. This is Midland Funding versus Brandy Wagner.
Yes, Your Honor.
And I believe she has not filed an answer and she is not here in Zoom. Okay. So give me the short version, if you will.
The short version is there's $4,241.57 owed on the account. The account was originally from Synchrony Bank and it was transferred to Midland Funding, and we're seeking judgment for $4,241.57.
Okay. And
Documents on file.
we're in our temporary office in the courthouse because our main office got flooded and it's under construction. And that, I have a sheet of paper with the case summary on it here, but the file is in the other office. Could you send me a motion for default judgment and the default judgment? Send that to us, and
I'll get them.
so we don't have to rummage around in the old office while it's under construction.
Do I have a good email address to get that to you?
It's WCJP1.
The one that's on the notice?
Yes.
ButlerCounty.us?
Yes.
Okay. I will have it sent over. Should be in about an hour or two.
Okay. And I appreciate that you're doing that.
Not a problem.
And do you have anything else?
Not until 2:30.
Okay. I'll see you again at 2:30.
See you then.
Okay. You're excused for now.